Good morning, everyone. We're going to go ahead and get started. My name is Keisha Amos. I am a third-year law student here at Thurgood Marshall School of Law. I am an intern at Harris County Attorney's Office, working in the CPS division, and I'm honored to be before you today. This section is an overview of humanitarian-based immigration relief available to children in removal proceedings. We have three speakers. Our first speaker is Ms. Dalia Castillo-Granados. Is that correct? She is the director of the American Bar Association's Children's Immigration Law Academy. She's a 2008 graduate of the University of Houston Law Center. Prior to working at CILA, Dalia was a senior attorney at Kids in Need of Defense, a staff attorney at Taharay Justice Center, a clinical supervising attorney at the University of Houston's Immigration Clinic, and she began her public interest career as a Greenberg Traurig LLP Equal Justice Works Fellow with Catholic Charities Cabrini Center in Houston. During law school, Dalia was active in the Immigration Clinic and interned at U.S. Citizenship and Immigration Services, Catholic Charities, and was a public interest law fellow at Boat People SOS. She was previously the chair of the State Bar of Texas Immigration Law Task Force. She is currently an executive committee member of the Houston Immigration Legal Services Collaborative on the board of directors for the Houston Association of Women Attorneys, and she is the president of Latino Giving Houston, a giving circle devoted to promoting philanthropy in Houston's Latino community. Second, we have Ms. Vanessa Perez. She is an EJW Crime Victims Justice Corps Fellow at the YMCA International Services. She represents trafficking survivors and other crime victims in front of the Department of Homeland Security and Immigration Court. Before working with crime victims, she represented immigrant children in family courts and immigration court. Vanessa was born and raised in Venezuela. She studied law at the Catholic University in Venezuela, and she has a Master's of Law degree from Georgetown University Law Center, and she's admitted to practice law in the state of Texas. Last but not least, we have Ms. Carolina Rodriguez. She was born in Lima, Peru, and raised in McAllen, Texas. She received her Bachelor of Art degree in Political Science from Baylor University and her law degree from Creighton University School of Law. After graduation, she began her career in San Francisco, California, representing adult clients in front of the San Francisco Immigration Court and USCIS office. She focused on removal defense, representing clients in family petitions, U visas, asylum and withholding of removal, cancellation of removal, bond hearings, and other forms of immigration relief. In 2014, Carolina moved back to Texas to represent unaccompanied children in removal proceedings. Prior to joining KIND, she represented both detained and released unaccompanied children as a staff attorney at Catholic Charities of the Archdiocese of Galveston, Houston. Carolina is licensed to practice Texas in law in Texas and Iowa and is fluent in Spanish. These ladies will be speaking for the next hour, and at the end we will have questions. We ask that during the question and answer portion, you wait until you have the microphone before you ask your question. We'll pass that around to you. Thank you.
All right, good morning. My name is Carolina Rodriguez, and I'm senior attorney with KIND, and I'm going to be talking today about Special Immigrant Juvenile Status, or SIJ. So SIJ is one of the more popular forms of relief that we see when representing unaccompanied children. SIJ is a classification or a form of relief that was created by Congress back in 1990 in order to provide humanitarian protections to abused, abandoned, and neglected children who were eligible for long-term foster care. Now, ever since then, Congress has expanded that definition of SIJ, and children are no longer required to be eligible for long-term foster care, but they still have to show that reunification with one or both of their parents is not viable. So what I'm going to talk about today in the next 20 minutes is we're going to talk a little bit about what are the requirements for SIJ status. getting a state court order, how to petition for SIJ, and applying for a permanent residency, which is our ultimate goal when seeking SIJ status for our clients. Now, SIJ can be pretty complex. I will do my best to condense this all in 20 minutes, but I will be around afterwards to answer any specific questions that you all may have. Well, I'm not going to go through what's AUAC because I think that you all have probably already seen that. So we're going to go right into how does a child qualify for SIJ? Now, SIJ is a very unique form of relief, and it's unique in the sense that it has a state court component along with a federal law component, which can seem confusing not just for your clients who have to go to both immigration court sometimes and state court, but also for the state court judges who are now found with these cases that also have federal law components, and they can sometimes be unsure as to what their role is within this federal law case of special immigrant juvenile status. So in order to qualify for SIJ, a person has to be under the age of 21, they have to be unmarried, and they have to be found to be dependent on a juvenile court or placed in the custody of an entity or an individual by this juvenile court. In addition, this juvenile court has to make specific findings that the child's reunification with one or both parents is not viable due to abuse, abandonment, or neglect, or a similar basis under state law. And they have to find that it is not in the best interest of the child to return to their home country. So one thing that I do want you all to keep in mind is that a child does not need to have the UAC designation to qualify for SIJ. So for example, if you're representing a child who is a UAC, but they have a sibling who may be entered with a parent, if that child meets these requirements, they can also apply for SIJ, even though they may not have that UAC designation. So for me, one of the first places that I go to when dealing with an SIJ case is the USCIS policy manual. I feel like here you can really find a lot of information on the background of SIJ, on the eligibility requirements or any sort of evidentiary requirements, and also information on appealing these cases in the unfortunate case that your SIJ case is denied. So I want to talk a little bit about some common SIJ scenarios. So these are the circumstances that should raise a flag for you when talking to a child to see if they maybe qualify for SIJ. One of the most obvious circumstances would be if there's physical abuse by a parent. I also put verbal abuse. However, I think verbal abuse on its own may not be as strong for an SIJ case, but it's one other clue that you can find when talking to your client to see if they could potentially qualify for SIJ. Also look for inaction by a parent. Did the parent fail to provide that child with food, with clothing, with shelter? Did they fail to remove that child from a dangerous situation where the child could not take himself or herself out of that circumstance? Also look for a lack of financial or emotional support. And ultimately, did that parent abandon the child with no intent of coming back to provide for that specific child? So in SIJ, we have 3 steps. First, we have that state component that I was talking about, which is obtaining a juvenile court order, which we do through a state juvenile court or a family court, as I will explain in a little bit. Once you are successful in obtaining your order with the special findings, you can then petition for SIJ status through USCIS, which now shifts the case to the federal law component of the case. And ultimately, applying for lawful permanent residency or becoming an LPR, which means that that child will become a green card holder. So let's talk a little bit about the requirements for this juvenile court order, which really is, I think, the big step for SIJ, because without this order, you cannot move on to the next step, which is actually filing your petition for SIJ status. So what SIJ requires is a finding that a juvenile court finds that the child is either dependent on the juvenile court or is placed in the custody of an individual or an entity. Now keep in mind that dependency and custody can vary from state by state. For example, here in Texas, we don't actually have this concept of custody. We have conservatorship and possession and access. Also, I do know that some states do have actual dependency statutes. Here it is a reference, but we don't have a defined statute for dependency. So here in Texas, we really focus more on findings of conservatorship and possession and access in order to meet this requirement for SIJ. Okay, skip something. Oh, no. Okay. So let's talk about juvenile court. So the statute actually does say specifically a juvenile court, but under the statute, this means that it's a court that has jurisdiction under state law to make determinations as to the care and custody of the juvenile. In Texas, there are other courts that also do this. So it's not necessarily, it does not necessarily have to be a juvenile court. It can also be a designated family court. It can be a juvenile justice court, a delinquency court, and a designated probate court. Here, at least in Harris County, most of our cases that are dealing with SIJ will get filed in family court. So that is what we here are mostly used to. I know back up until about 4 years ago, some of these cases were also being heard in the Harris County Juvenile Court, but for right now, they're mostly in family court. All right, so we're going to talk about custody versus dependency and which one's the one that we should go for here in Texas. So the best method in my practice, and the one that we use as well at Kind, is that we try to seek these findings through a petition family court for a SAPSR, for conservatorship. And we do this through a petition for suit affecting the parent-child relationship. It is also possible to get these findings and through a declaratory judgment or a guardianship order from probate court. Personally, I don't recommend those last two. I know that in the past, some other practitioners have had some pushback in the probate court in getting guardianship orders with the special findings. And declaratory judgments have been difficult because you're not making a custody determination. And because we don't have a dependency statute here in Texas, USCIS has come back to say that those are not enforceable and therefore they will not count for SIJ purposes. So if you are handling a case here in Texas and Houston, I definitely say move forward with the SAPSR as opposed to trying to do a declaratory judgment or a guardianship. So to go through some of the basic steps, and again, this can be a fairly lengthy process sometimes, but I'm going to try to condense this as much as I can. So for the first step, you need to have an adult who will petition for the child before the family court. So normally this will be the Office of Refugee Resettlement sponsor, who's the adult the child is currently living with. A lot of times that will be one of the child's parents, or it can be another family member, but it has to be an adult who is willing to petition for conservatorship of the child. What is important, though, is that keep in mind that for SIJ, you have to make findings against one or both parents. So you can have a parent as the petitioner, but keep in mind that you still have to make those special findings against another parent. So after you have an adult petitioner, you then have to initiate a service against the respondent parent after you file the initial petition. So you can actually serve the respondent parent through personal service or alternative service or publication. A lot of times, the respondent parent will actually be in home country. So that can sometimes be a little bit tricky because you have to sometimes publish in the child's home country as opposed to doing it here. So it's really important to have an open dialogue with the judge that you are working with to make sure they're comfortable with the form of service that you will be using in your specific case, especially if that respondent parent is not currently in the United States. So after you've initiated service, you have to prepare your evidence. You need to make sure that the judge has the factual basis to be able to make the findings of conservatorship, possession and access, and as well as the special findings that you need for SIJ. I like to include affidavits from the petitioner. Depending on the child's age, I will sometimes get an affidavit from the child as well. But again, we don't want to re-traumatize the children in the case, so we have to be careful about getting a declaration from the child. In some cases, you may have access to police reports if there's been past abuse or medical reports. However, since our children, they are unaccompanied children, a lot of times they don't have that information or are not able to get those documents. So if you do have that, obviously you want to translate that and you want to submit that, but that may not always be the case. Some cases will also require an adjudication of paternity, which can be tricky in cases where the parent is not on the birth certificate and the parent is not here in the United States. I know we've had some pushback with some of the judges because we have not been able to obtain a personal jurisdiction over a parent that's not on the birth certificate or is not present. So that's something also that I would strongly recommend, that if you have a case where you're going to have paternity issues, to discuss either with your pro bono mentoring attorney or to talk to another practitioner who has done these cases before to kind of, guide you through the process of establishing paternity. In some cases as well, where, for example, you've had a publication, you will be required to get an ad litem attorney. In the past, some courts were also requiring an amicus attorney to look out for the best interest of the child. We've not really seen that as much in the past year or so, and that's actually been very beneficial to us, because every time we have to get an ad litem attorney or an amicus attorney, those costs have to be covered by the petitioner. And our clients already are struggling financially, so it has been quite a financial burden for some of our clients to have to pay for an additional amicus attorney or an ad litem attorney. The final step in this process, at least for the juvenile court order portion, is to get a final order. Now, I know that earlier I said that a child can petition for SIJ until the age of 21. But you do have to keep in mind that the court is issuing this order has to have jurisdiction to make those determinations of custody and care of the child. And here in Texas, the age of majority is 18, which means that that final order can only be obtained up until the child is 18 years old. So even though they can apply for SIJ until they're 21, they will only be able to obtain that order until the age of 18. So please keep that in mind when you have a child who's about 17 and a half. You will not have as much time, even though the SIJ statute does say that you have until the age of 21. I want to talk a little bit now about some of the SAPSR findings that we are trying to obtain in that order. We need to have a grant of the petitioner as a sole managing conservator, which means that that is the person with decision-making rights over that child. We also want to deny the respondent possessory conservatorship, which means any sort of decision-making rights over that child due to abuse, abandonment, and or neglect. And we want to deny or limit the respondent's possession and access due to abuse, abandonment, and or neglect as well. In addition to those findings, we still need to get the SIJ special findings that are required for us to proceed to the next step of seeking SIJ status. So the SAPSR special findings, I know that in some states, for example, the special findings will be a separate document to the actual custody order. But here, at least here in Harris County, we get all of these findings all in the same SAPSR order. We put the special findings under the conservatorship section. And those special findings are the following. We need to find the child was abused, abandoned, or neglected by the respondent under the definition of abuse, abandonment, or neglect under Texas law. And we want to be really explicit about that because we want to, I personally like to include the Texas Family Code citation for abuse, abandonment, and or neglect to make it clear for USCIS that these findings were made under Texas law and not under federal law. We need a separate finding that the child's reunification with the respondent is not viable due to the abuse, abandonment, and or neglect. And again, make sure to include that Texas Family Code citation to make it extra clear for USCIS that all of this is being done under Texas law, not federal law. And finally, that it is not in the child's best interest to return to home country. And this is very broad, right? What does it mean for a child to not be able to return? For us, what that's meant is that there's dangerous conditions in the child's home country that make it impossible for the child to be able to find a proper placement in their home country. So for example, if a child has been recruited by gangs in their home country, that is a dangerous condition that would make it difficult for the court to find a proper placement for that child in home country. Also, if there's no one willing or able to care for the child in home country, if the child says, the only person that I have in my home country is my grandmother, but she is elderly, she has health issues, and she's not able to care for me, and there's gangs that are out there who are recruiting me, and she will not be able to protect me. So there we have a person who is not able to care for this child, and there are dangerous conditions that don't allow for there to be a proper placement for that child in home country. So one thing that I do want to mention, because I know this has come up for me in the past when doing SAPSERs in family court, is that a lot of times I have to make it very clear to juvenile or the state court judges that they are in fact not granting SIJ status to the child, and that they're not granting any sort of legal immigration status to the child. Sometimes it can be very hard to see that line between what is the state court a component and the federal law component. So just make sure to tell the adjudicator that they are not making any sort of immigration finding. This is just one of the requirements for SIJ, that after you obtain this order, you still have to go in front of USCIS to have them determine if the child qualifies for SIJ. And even then, there's a very strict process afterwards in order for the child to be able to apply for a green card, which includes a fingerprinting, an interview, it includes a medical exam. So they are not granting legal status to this child. So I think if you find a judge who is very hesitant to make these findings, just make it clear to them that they are not actually deciding federal law, that they are only deciding things that are state court. And the reason why they're doing this is because USCIS is not equipped to make findings of abuse, abandonment, or neglect for a child. That they really are the ones that are equipped to make these findings. So that's why USCIS looks to them to make the special findings, but they don't determine the child's legal immigration status here. Okay, so now we get into the federal law part of the case. So after you've obtained your order and hopefully has all of the SIJ findings that you need, you then need to file the child's petition with USCIS for special immigrant juvenile status. And the way that we do this is by completing Form I-360, which you can find at uscis.gov. It's completely free. And you need to include proof of eligibility. One, the child is not married, that they're under the age of 21, and that you have a juvenile court order with the required findings. In some cases, they could have an interview. I personally have not seen an interview in a very long time for SIJ, but I know in the past they used to do interviews as well. Now, there are cases where you could get what's called a request for evidence, and that is in cases where USCIS may need additional evidence before making a final decision. A lot of times, these requests for evidence are because they want to make sure that the findings that were made were done under state law, or they want to know what is the factual basis, what is the evidence that the judge looked at before making these findings. So a lot of times you can actually overcome this request by providing a copy of the evidence that you submitted to state court, or a copy of the transcript of the testimony that was taken at the prove-up. Also, keep in mind that if your case is denied, these cases can be appealed. But I'm not going to go into it right now because it's a whole other topic. It would take way too long. So a few things about SIJ that we need to keep in mind. Unfortunately, even if a child does get SIJ granted, that does not give them a work authorization, which is really unfortunate because at the time between getting an SIJ application granted until up until a time where they can actually apply for their green card can be a very long waiting period. And unfortunately, during that time, they will not have any sort of work permit. Also, SIJ does not grant the right to re-entry into the U.S. if the child leaves the United States. Also, keep in mind that a child cannot apply for SIJ from outside the U.S. SIJ should also prevent the child from being removed or deported from the United States, and technically should be a basis for a continuance in immigration court. Just recently, we've been having some pushbacks with that. Some judges have not been as willing to give continuances for SIJ only because it is a form of relief that's adjudicated by USCIS, and it's not, according to the immigration judge, it's not a form of relief within their court. But for the most part, it should be basis for a continuance. Also, the child has to remain unmarried up until the time they're able to apply for, they're able to obtain their lawful permanent resident status, which again can be unfortunate because it is a very long waiting period right now. And if your child turns 18 or they're older, they will have to continue waiting to get married until they obtain their LPR status. Also, Parents of SIJ recipients cannot obtain immigration status through their children, even after their kids become U.S. citizens, if that is the case. And that applies even for the good parents. So in cases, for example, where you have a good parent as the petitioner and they are making findings against a respondent, which is the bad parent, even that good parent is unable to obtain status from their child even after they become a U.S. citizen. So our final and our goal really in all of this is to help our clients adjust status, which means to be able to become a lawful permanent resident, which means to get their green card. So the first requirement is the child have an approved immigrant petition with an immediately available immigrant visa number. And this is a part that's tricky right now. Right now there is a very major backlog right now in visa numbers. So right now, children are waiting for many years in order to be able to adjust their status. So there is a very, very long waiting period right now. Also, during this time, they cannot become inadmissible. So one thing that I always try to make sure to tell my clients is they have to, stay out of trouble, not have any issues with the police during the time that they're waiting. They cannot leave the country. They just have to wait until their visa number is current and they're able to apply for lawful permanent residence as well. Also, now, since there is a very long waiting period, do keep in mind that the child does not need to be under the age of 21 to apply for their green card. Unlike SIJ, where they have to be under 21 to apply for SIJ, that does not apply for adjustment of status. They can be over the age of 21. In regards to steps to filing for lawful permanent residence, they have to complete what's Form I-485 application, which again can be found on uscis.gov. Now, this application does have a filing fee. However, they can seek a waiver of that fee if they are unable to pay it. And this can be filed either by mail or it can be filed with the court, depending where the child's immigration case stands. If their case is still going on in immigration court, then the adjustment of status will be done through the court. If the child's case has been terminated and they're no longer going to court, then they can actually do this process through USCIS. One of the perks of being able to apply for adjustment of status is they can also concurrently apply for a work permit, which is what a lot of the kids want. They want to be able to have that ID. They want to be able to work once they reach the age of where they're eligible for employment. And finally, they will have a USCIS interview if they apply through USCIS, or they will have a hearing in front of the immigration court in order to adjust status. If approved for LPR status, they will be able to get a green card and will be able to live permanently here in the United States. So just a few rights and duties of a person with LPR. If a kid gets LPR, they're able to live and work permanently in the United States. They can leave under certain conditions and return back to the U.S. And I think what is the ultimate goal for many of these kids is that after 5 years, they will be able to become citizens if they're allowed to, after they have their LPR, their goal is to be able to apply for citizenship after 5 years as well. Now, along with these rights, we have responsibilities that are not as fun, such as, paying taxes. They have to pay taxes once they start working. They have to follow laws. And also they have to register with the Selective Service for all males between the age of 18 and 26 and maintain their lawful immigration status throughout the time. So that way, after 5 years, they're able to obtain or apply for citizenship as well. So that is a very quick intro to SIJ, but I will be around afterwards, or please feel free to email me if you have any specific questions about any SIJ matters. Thank you.
Hi everyone, my name is Dalia Castillo-Granados, and I'm the director of the Children's Immigration Law Academy, or CILA. So thank you, Carolina. That was very clear on SIJ. And another form of relief that's very popular for, or that unaccompanied children may qualify for, is asylum. So we'll try to go over a quick overview of what asylum is. So first, we'll start with the sources of law. The two major sources of law on asylum are domestic law and international law. The Immigration and Nationality Act was amended by the Refugee Act of 1980 to be in compliance with international obligations, and the asylum statute can be found at INA Section 208 or Title 8 of the U.S. Code 1158. The relevant regulations can be found at Title 8 of the Code of Federal Regulations 208.13. Another source of important sources to look at is case law. And you're going to want to look at Board of Immigration Appeals decisions. And the Board of Immigration Appeals is the appellate court that reviews immigration court decisions. And you can also appeal BIA decisions from to the circuit court, and in Texas, that would be to the Fifth Circuit. And you can further appeal Fifth Circuit opinions, of course, to the Supreme Court. So all of these are going to be important sources of law. There's also, it's also important to look at other circuit courts, because those could be persuasive authorities, especially if the circuit court that you're in doesn't have, hasn't ruled on a specific issue. And then, as I mentioned, asylum law is derived from international law, so these sources can also be persuasive. The 1951 United Nations Convention relating to the status of refugees and the 1967 United Nations Protocol relating to the status of refugees are two international treatises that have had the most impact on U.S. law. And then also, finally, the UNHCR has issued a handbook and guidelines on procedures and criteria for determining refugee status. And as a complement to that handbook, there's been guidelines on different topics. In 2009, the Guidelines on International Protection number 8, Child Asylum Claims, was issued. And that's a really good source to look at. So, in order to qualify for asylum, an applicant has to be physically present in the U.S. and meet the definition of a refugee under INA Section 101A42A. So there's 3 grounds that could make somebody ineligible for asylum. And the first is that the applicant can be removed to a safe third country. So the country must have first signed a safe third country agreement with the U.S. And currently the only active safe third country agreement is with Canada, although the current administration has tried to sign other safe third country agreements, and there's ones pending. I don't believe they're active yet for Guatemala, El Salvador, and Honduras, which is really going to limit protection for asylum seekers. The second ground of ineligibility is the 1-year deadline. So somebody who wants to apply for asylum must do so within 1 year of arriving in the U.S. Unless you can prove that there's changed or extraordinary circumstances that prevented the filing of that application. And both of these grounds, safe third country and 1-year deadline, do not apply to unaccompanied children. And that's statutory. It's under the statute at INA 208A2E. And then finally, if somebody's applied for asylum before, then they can't apply again unless they can prove that there's been changed circumstances. Along with these grounds of ineligibility, there's also 6 statutory bars to preventing somebody from being granted asylum. So those are if the applicant has persecuted others, that the applicant has committed a particularly serious crime in the U.S., that the applicant has committed a serious non-political crime outside the U.S., that the applicant is a danger to the security of the U.S. or has participated in terrorist activities or given material support to a terrorist organization, or if the applicant has firmly resettled in another country before arriving to the U.S. As Ann and Jerry spoke about this morning, there's continued attacks on asylum seekers, and so there's some additional bars to asylum that we call Asylum Ban 1.0 and Asylum Ban 2.0. So Asylum Ban 1.0 was issued on November 9, 2018, and sought to bar asylum for persons who did not enter through a designated port of entry. So the implementation of this ban was blocked by the U.S. District Court for the Northern District of California through a nationwide preliminary injunction. The Ninth Circuit and the Supreme Court have both denied the government's request for an injunction. And really, I think this is because the ban is inconsistent with the plain language of the statute, which says that any alien who's physically present in the United States or who arrives in the United States, whether or not at a designated port of entry, may apply for asylum. Now, that didn't stop the administration from issuing a second ban, and this is Asylum Ban 2.0, which was issued as an interim final rule on July 16th, 2019, and it bars asylum for any person who crossed through another country before reaching the U.S. without seeking asylum in that country first. Now, there was another nationwide preliminary injunction that was issued by the same U.S. District Court, but the Supreme Court has lifted the injunction on September 11, 2019. So this bar does apply to everybody, including unaccompanied children who entered the U.S. after July 16, 2019. There are some exceptions to this ban, and that includes for people who applied for asylum in another country but were denied, those who are victims of human trafficking, or those that cross through a country that's not a signatory to one of these international protocols. So, as I mentioned, in order to qualify for asylum, you have to meet the definition of a refugee, which is found at INA 101A42A. So the definition is broken down here on this slide. A refugee is defined as a person who is unable or unwilling to return to or unable to avail themselves of the country's protection because of past persecution or a well-founded fear of future persecution on account of one of the 5 protected grounds: race, religion, nationality, political opinion, or because they're a member of a particular social group. So we're going to spend the rest of the time looking at each element separately. And the first is that the applicant has to show that they're unable or unwilling to return or avail themselves of the protection of their country. So the first determination that you're going to want to make is what country of nationality your client is, what country your client is from, and then whether or not they're able or willing to return to that country. If they did return to the country, it doesn't mean that they automatically don't can't apply for asylum, but there's going to be some factors to consider. And being unable or unwilling to avail yourself of protection can easily be proved by the filing of the asylum application here in the U.S. So one of the most complicated parts of asylum is proving persecution, and persecution is not defined either by the Immigration and Nationality Act or by the regulations, so you really have to look at case law when it comes to figuring out whether your client meets the definition of persecution. So there is a case, a Board of Immigration Appeals case, matter of Acosta, which defines persecution as harm or suffering inflicted upon an individual in order to punish the individual for possessing a belief or characteristic the persecutor seeks to overcome. UNHCR has found that persecution can include threat to life or freedom, or other serious violations of human rights, such as genocide, sexual rape or sexual assault, slavery, or the repression of freedom of thought, conscience, or religion. So persecution can also include other things like physical harm, serious threats, cumulative harm, psychological harm, harm to family members, especially in the context of children's claims, economic harm, or harassment and discrimination. But not all circuit courts agree on whether these acts rise to the level of persecution, so it's going to be important to look at case law in your jurisdiction. So, if the harm suffered or feared rises to the level of persecution, then the applicant has to show that the persecution already occurred or that the persecution they fear is well-founded. One thing to keep in mind is that past persecution and future persecution can provide 2 separate bases for asylum, so it's going to be important to consider each possibility separately. So past persecution can establish eligibility for asylum if it's on account of one of the 5 protected grounds and was committed by the government or a person or group that the government is unable or unwilling to control. If past persecution is established, then the applicant is presumed to have a well-founded fear of future persecution. So the burden shifts to the government to rebut that presumption by showing either that there's been a fundamental change in circumstances or that your client could internally relocate in their country to avoid further persecution. If the government does rebut that presumption and shows either that there's been a fundamental change in circumstances or that your client can internally relocate, then you can still qualify for asylum under humanitarian asylum, which is otherwise known as asylum in the absence of a well-founded fear of future persecution. So you can establish eligibility for asylum if the harm was severe and atrocious, or if there's a reasonable possibility of other serious harm. And there are two cases that discuss these two grounds further. So establishing past persecution is not going to be the only way that you can establish eligibility for asylum. You can also establish that you have a well-founded fear of future persecution. So in order to establish a well-founded fear, the applicant has to show that there's a reasonable possibility of persecution. There's a Supreme Court case, INS versus Cardoza-Fonseca, that finds that establishing even less than a 50% chance of the event taking place may qualify for asylum, and even suggested that a 10% chance of persecution can amount to a reasonable possibility. So in order for the fear to be well-founded, the applicant has to show both a subjectively genuine fear and an objectively reasonable fear. And there's a case, matter of Mogherabi. It's a Board of Immigration Appeals case that sets out a 4-part test to determine whether the applicant has a well-founded fear of future persecution. So the applicant has to show that they possess the belief or characteristic that the persecutor is trying to overcome, that the persecutor is aware of that characteristic or belief, that they have the capability to actually persecute the applicant on that ground, and that they have the inclination to do so as well. Some other important considerations for the well-founded fear analysis are going to be the following factors. It's going to be on the applicant to prove that they can't internally relocate to another part of the country. And internal relocation, it has to be reasonable. A specific threat of harm may not be enough to establish past persecution, but it can be a consideration to establishing a well-founded fear of future persecution. Another consideration is going to be if the applicant remained in the country after they became aware that there might be a possibility of persecution. If the persecutor is the government, then possessing valid travel documents might become an issue. And if it's not the government, that may not become an issue. And then usually an applicant has to show an individual fear of persecution, but if there's a pattern or practice of persecution against a group or a category of persons that are similarly situated, then the applicant doesn't need to prove that they would be singled out. And then finally, another consideration is whether people that are similarly situated, such as family or friends, have been similarly targeted. So along with showing either past persecution or a well-founded fear of future persecution, the applicant also has to show that the persecution is on account of one of the 5 protected grounds. So the relationship between the persecution and the protected ground is called the nexus. And the most important part of establishing the nexus is whether the persecutor's motive for harming or seeking to harm the applicant is based on one of the 5 protected grounds. So the motivation can be shown through direct evidence, such as by the persecutor's own statements, or circumstantial evidence, such as country conditions reports. And it's important to remember that the persecutor can also be motivated by several different reasons for harming. So there's no requirement that the protected ground is the only reason that the persecutor is motivated to harm. So along with establishing motive, the applicant also has to show that the past or future persecution is due to one of the 5 protected grounds: race, religion, nationality, political opinion, or because they're a member of a particular social group. So the applicant has to show that they actually possess the protected ground, or that the persecutor imputes that belief or characteristic to the applicant. And the 5 protected grounds are either all immutable, they cannot be changed, such as race or nationality, or fundamental, so that they should not be required to change, like religion or political opinion. And membership in a particular social group can either be immutable or fundamental. Now, a particular social group is going to be one of the grounds that most children from Central America use, so we're going to talk about it in a little more depth. In order to claim relief under particular social group, you have to first identify the group and then determine whether the applicant is actually a member of that group, and then determine whether the persecutor's motivation to harm the applicant is because of that membership. So just like the other 4 protected grounds, membership in a particular social group can either be immutable or fundamental. In matter of Acosta, which we've already discussed, the BIA explained that the characteristic that defines the group must be one that the group either cannot change or should not be required to change because it's fundamental to their identities or consciousness. Now, the immutable or fundamental characteristic standard remained the standard until the BIA added 2 new factors to this protected ground, and those are social visibility and particularity. And these were introduced as concepts in 2006 with a case called Matter of CA. Social visibility was later changed to social distinction, and that's why we have it described so here. But it really wasn't until 2008 that these became the official new requirements with 2 cases called Matter of SEG and Matter of EAG. So after these 2 new requirements were introduced, there was a significant amount of litigation at the circuit court level, and so the BIA issued 2 new decisions, Matter of MEBG and Matter of WGR. And these cases renamed, like I said, the social visibility requirement to social distinction. And the definition for social distinction is whether a group is perceived and recognized as a distinct entity by society and not just by the persecutor, which is definitely a change in the way that things were interpreted before. And then the definition for particularity is whether the group is sufficiently distinct that it would constitute a discrete class of person with definable boundaries. So the BIA said that if it was amorphous, overbroad, diffuse, or subjective, then it wouldn't meet this requirement. So once the applicant shows either past persecution or a well-founded fear of future persecution on account of one of the 5 protected grounds, now the applicant has to show that the persecution is either by the government or by a group that the government is unable or unwilling to control. So government actors can be national authorities such as political leaders, members of the military, or they can be local authorities like members of the police. If the government is the persecutor, then there's no requirement that the applicant show that they sought protection from the government. Now, the persecutor can also be a non-governmental actor. There was, and it was discussed this morning, a recent Attorney General decision, Matter of AB, that requires that the government either condone the private action or was completely helpless to protect the victim. But there's been ongoing litigation, and so that increased standard was said is not to be followed, although you should still consider it when looking at these cases. So one relevant factor in this determination is whether the applicant actually sought protection from the government, and if not, the reason why not. If the applicant never sought protection, that doesn't mean that they don't qualify for asylum, but you would have to explain why the applicant felt that it was futile to try to go to the police or to the government for protection first. The evidentiary standard was amended by the Real ID Act of 2005, so the applicant's testimony on its own can be enough to establish eligibility if the testimony is found to be credible, persuasive, and refers to specific facts. So credibility is going to be a really important consideration when judging these cases. The adjudicator can request corroborating evidence, and the applicant has to provide that corroborating evidence unless they can show that the evidence is not available or cannot be reasonably obtained. So some tips specific for children's asylum claims. As Ann and Jerry mentioned this morning, there's constant attacks against asylum as a form of protection and against asylum seekers. So it's really important to become an expert on the asylum basics. We've mentioned matter of AB a couple of times now, and it's an Attorney General decision that tried to say that claims, especially from Central American families and children, would not qualify for asylum. And I think they conflated a lot of the elements that we just went through. So it's going to be really important to become an expert on the asylum basics so that you can write out a really good brief and explain that you're meeting all of the elements for asylum. It's also important to understand the procedural posture of the case. There are some special protections for children, and you should know what those protections are. And even though the current administration is trying to take away those protections, you should still keep fighting to keep those. It's also important to try to humanize your client. Adjudicators from the asylum office or from the immigration court hear stories all the time, and it's important to remind the adjudicator that your child's story is unique. And you should look at other protected grounds and not just particular social group. Things like religion or political opinion, you might want to also mention as part of your strategy. And then always ask the adjudicator to apply the children's asylum guidelines, which are still guidelines that the administration is supposed to follow, the government is supposed to follow. There's a lot of negative case law. It's important to distinguish that case law, or if you can't distinguish it, to argue why it's not correct. And then finally, always preserve all of your arguments for appeal, because you might have to appeal your case. And as Jerry mentioned, the current trend against asylum seekers might not always be the case, and so it's important to keep those arguments on record. So as I mentioned, the children get special protections. So a child, even though they're in removal proceedings, doesn't have to present their case to the immigration court first. They can do so at the asylum office, and that's not the way it goes usually. That's not the way things usually work. And so it's important to know that this is a statutory protection, and that there's policy that you should follow, that there's policy that you can look to for guidance. So the administration issued a new memo called the Lafferty Memo just this summer, but that memo there's been a temporary restraining order against it, and so what you should follow is the Kim Memo for 2013, which says that a child who was designated an unaccompanied child remains so for the duration of their case. So we've already talked about particular social group, and I know I mentioned that you should look at other protected grounds, but here's just a reminder that to make a good and cognizable social group, you always have to start with nexus and ask yourself, why was the persecutor targeting the applicant? And it could be any of these characteristics together that makes your client part of a particular social group. Whenever possible, and this is advice that's more relevant to the asylum office, but you should try to avoid coming up with novel particular social groups and instead look at what's been approved already by the circuit courts, and not just the Fifth Circuit, but the asylum office can look at any circuit. And so these are going to be some of the established particular social groups that you should put forward. When it comes to the immigration court, I think there's wider latitude, and you should try to preserve all arguments, and so you can make the case for a novel particular social group if you would like. And then finally, always use the government's words against them. The guidelines are still, you should still always look at the guidelines. So, the asylum officers has to keep in mind the child's age, have child-friendly interviews. If a child feels more comfortable with a female officer, for example, they should get one. The standard for persecution might be a little bit lower for children. So this is all part of the guidelines, and you should put it as part of your brief. So that was in a nutshell. And I think I'll turn it over now to Vanessa to discuss UT and VAWA relief.
Hi everyone, I'm Vanessa Perez, and I'm from the YMCA. I'm a EJW fellow. I work with crime victims mostly, some of them minors. So I'm going to talk about other reliefs available to children, immigration reliefs. I was told I only have 10 minutes and we have to cover 3 reliefs, so I'm going to go quick, okay? But if you have any questions, feel free to reach out to me afterwards via email or just stop me outside. I'm going to start with the Violence Against Women Act, or VAWA self-petition. So the Violence Against Women Act addresses a common problem. Let me just go, sorry. Okay. Oh, I'm sorry. Oh, no, okay. So it addresses a common problem. Abused non-citizens, they stay in abusive relationships many times because they have an abusive family member that has vital key or important key in their immigration status. U.S. citizens and lawful permanent residents can petition for certain family members through a family petition. So sometimes they will use that power to control an abused non-citizen. And undocumented non-citizens usually fear deportation or because they don't have an immigration legal status. So keep that in mind when you're interviewing your children or your clients if they have been abused by a family member that is a U.S. citizen or lawful permanent resident. So VAWA self-petition was created to allow those immigrants subject to abuse by their spouse, parent, or an adult child to obtain permanent residence without the participation of the abuser. So the requirements for VAWA are that the abuser must be a U.S. citizen and a lawful permanent resident, or a lawful permanent resident, that the victim must live in the United States, that the victim must have lived together with the abuser at some point, that the victim must have been subject to battery or extreme cruelty, including psychological abuse, physical violence, or even sexual abuse. They must also show that they have good moral character, the victim, meaning that they don't have any criminal history. And if the petition is based in a marriage, even if they are children, but if it's based in a marriage, the victim must show that they marry the abusive spouse and that they marry in good faith and not for immigration purposes. So if the victim can prove all those requirements, they can apply for VAWA with the immigration office. And the petition, if it is approved, they will obtain deferred action. Deferred action comes with a work permit, so they will obtain a work authorization. It's not a legal status, but it will allow them to apply for residency without the participation of the abuser. So if the victim is an immediate relative, and that means that if the victim is a spouse, the children, all married under 21, of a U.S. citizen, or the parent of an adult child that is a U.S. citizen, the victim can apply immediately for permanent residency. However, if the abuser is a lawful permanent resident, then the victim may need to wait until a visa becomes available. So that was one of the things to consider. Some abuse victims who are non-citizens may also qualify for other type of relief. They may qualify for a non-immigrant status, which is commonly referred as the U visa. So the U visa, the U non-immigrant status was created with the purpose of protecting victims of certain crimes who have the courage to come forward to report the crime and to help with investigation or the prosecution of the crime. And the U non-immigrant status will provide them with a temporary legal immigration status in the United States. A temporary because it lasts for 4 years, but after the 3rd year, if they can show that they have been or they have lawful presence in the United States, they can apply for permanent residency. It also improves, and that's one of the other purposes of the U non-immigrant status, it's to improve law enforcement's ability to prosecute and to investigate crimes. To qualify for a U visa requirement, the requirements are that the victim must have suffered substantial mental or physical abuse as a result of being a victim of the qualifying crime. They must show that they possess credible and reliable information about the crime. They must show that they have been helpful or they are likely to be helpful to law enforcement with the investigation. And they must show that the crime has happened here in the United States. In order to show that a person was helpful with investigation, the victim must request from law enforcement, and that could be the police or the government attorney, any law enforcement agency, they must request a certification. So law enforcement will issue or complete an immigration form stating or certifying that the victim is a victim in a case they're working on, and that the victim has been helpful, okay? Without the certification, the victim will not be able to apply for a U visa or your U non-immigrant status. Well, right now there is a cap. There is a cap for U visas. USCIS can only grant 10,000 visas a year, and last time USCIS published some numbers, which was a couple years ago. They were saying that more than 130,000 U visas are pending, which if you do the math and only 10,000 can be granted a year, that means for clients and for minors that the children that are applying for U non-immigrant status will be waiting years to get a decision on their case. So right now, USCIS processing times are showing that USCIS officer will decide on your case in 4.5 years after the filing date. So during those 4 years, the applicant would have a no lawful status, and if they are in proceedings, which many of the children are, the judge will have to decide. Usually they don't want to wait for USCIS to adjudicate a union immigrant status. So in that case, they will probably ask for another relief, and you will have to be ready to present another relief. And so USCIS, if gets the time where you can get a decision after the 4.5 years, they will, what will actually happen is they will sometimes, and most of the times, they will grant deferred action and put you on a wait list, put the applicant on a wait list until more U visas are available, until you're able to be on that top to 10,000 and you have a U visa available to get granted. During that deferred action, you can get, or the client can get employment authorization, but they are, it's not a lawful status. They're still waiting. And once the U visa is granted, like I said, after the 3rd year of showing lawful presence, the applicant can apply for permanent residency. And after 5 years of being a permanent resident, they can apply for citizenship. Finally, the T non-immigrant status was created for the same reasons of the U visa or the U non-immigrant status, was created to protect survivors of human trafficking. So it is directed to survivors of human trafficking, and it does provide a temporary immigration status. It's also for 4 years, and it's the same. After showing lawful presence for the 3rd year, you can apply for permanent residency, and after being a resident for 5 years, you can apply for citizenship. To be eligible for a T visa, a non-citizen trafficking survivor must show that he or she has been a victim of severe form of trafficking, and the definition, according to the Trafficking Victims Protection Act, is that you have 2 types of trafficking: sex trafficking, in which a commercial sex act is induced by force, fraud, or coercion, or in which the person induced to perform such an act is 18 years or younger. So children under 18 do not need to show force, fraud, or coercion. And the second definition for trafficking or type of trafficking is the recruitment, harboring, transportation, provision, or obtaining of a person for labor or services through the use of force, fraud, or coercion for the purpose of subjection to involuntary servitude, peonage, debt bondage, or slavery. The second requirement is that the survivor should show that they are physically present here in the United States on account of trafficking, and that could be because they just recently escaped the trafficking. It doesn't mean that they were trafficked through the borders or into the United States. They could have come to the United States willingly, and then while being here, they've been trafficked. So it means that you have to show that you are currently here either receiving services that because of the trauma you suffer due to the trafficking, like counseling or other services, social services, or you have to show that you just escaped your trafficking situation, or you escaped but you are receiving services, or you are currently helping with investigation or prosecution of the trafficking. The third requirement is that the survivor has complied with any reasonable request for assistance in investigating or prosecuting the trafficking. And reasonable means that that law enforcement can ask the survivor to cooperate, but they cannot ask them to put in harm's way, to put themselves in harm's way, or to be hurt, or to be put themselves in where the trafficker can hurt them or kill them. So just keep that in mind. And that requirement is not applicable for minors. It's minors are exempt to show that they have cooperated with law enforcement, and they don't even have to report the trafficking. And the last requirement is that the survivors will suffer extreme hardship involving unusual and severe harm upon removal. So for minors, like I said, they don't have to show that they were forced, under fraud, or coerced to be trafficked. They just, for example, in sex trafficking, they would just have to show that they were induced to the sex trafficking, and that's it for applying, or the requirements for applying for a T visa. They do have to show that they're here on account of trafficking. Like U visas, T visas are also subject to a cap of 10,000 visas per year, but it's never been met. So there's visas available. Use at T's also include a waiver of ground of inadmissibility, like overstaying a visa or entering without inspection or admission. You can include all those grounds of inadmissibility with your application. And finally, we wanted to let you know that in many cases, you look at this SIJ and asylum reliefs, but also, consider and have in mind all the reliefs, immigration reliefs available. All three that I talked about, the VAWA, the UE non-immigrant status, and the T non-immigrant status, are adjudicated with USCIS, with the Immigration Office. And so it's different how you will present them in court. It will depend on the judge on how they would like to see it. For VAWA and T visas, the waiting time is to have a decision is less than for U visas, but still it's between 1.5 years and 2.5 years right now. Well, if you have any questions, I don't know if we have time for questions, but thank you for listening.